I'll begin our conversation here in studio. Remember, we're putting special focus on that NASA petition as we wait for the Supreme Court judges to deliver a ruling or a judgment this Friday. We don't know what the time, but those are details that we'll get to know in the coming days. All right, let me start by introducing my guest here in studio. I'll start from my extreme right, Nelson Harvey, not a new face here on Kivumbi 2017. He is a lawyer and he's going to be talking to us about this. He's also been following this process quite keenly over the last couple of weeks. We also have Felix Odhiambo, also someone who's very close to our coverage here on KTN News. He is an electoral law and governance expert. Thank you very much for your time. All right, so Felix, you're from Angola and you were following the election there. So we'll be getting into the discussion of what really was different or similar with the Kenyan situation. But I'd like us to start the conversation from the petition, the NASA petition. What can you assess from the conduct of the case, just generally? We'll get into the details in a minute.
First of all, it's good to be back.
Yeah.
And I think the Supreme Court petition for 2017 election was a major landmark in our history, one that will serve to continue test our democratic institutions. I think I echo and reiterate the observation that many people have made actually with regard to the conduct of the Supreme Court judges, the way the proceedings were conducted, the objectivity that the Supreme Court judges conducted themselves, and I think major decisions were made, even in the interim period, on the applications that were made that substantially departed from the jurisprudence that was set during the 2013 elections, and I think we'll be able to talk more about that.
Exactly. Nelson, your assessment of the court sessions, I saw on your social media, very active. What is your assessment of just how the conduct of the judges were and general environment of the court?
There has been a substantial development in the manner in which the Supreme Court has designed its systems to ensure that it conforms to the constitutional requirement that mandates it to be a people's court. It needs to be remembered that the main function for which the Supreme Court was designed under the Constitution was because the people had felt that the High Court and the Court of Appeal had in previous occasions not addressed challenges to the election of the president in a manner that indicates that justice has been served. So far, and I think if you were to follow the proceedings, the manner in which they were conducted, you could see a very orderly court, a people-oriented court, a court that sought to simplify things. I think in the manner in which you saw judges interjecting and asking simple questions, it became quite clear that despite the legal jargon and prose or poetry that many advocates purported to use, which, sorry to speak, people always claim that we advocates use big words.
Yes, extremely big words.
We will not use big words here. But you could see the courts demolish the big words with a simple question like, where did the 5 other ballot papers go? You understand?
Yes.
And that is the simplicity with which a Supreme Court is supposed to handle a presidential election, with the result that even the Githeri man is able to understand exactly what happened and why did it happen like that.
And it's true, because also just following on social media, quite a number of Kenyans really wanted to know what exactly was happening, and they were following through no matter the time, no matter if it was working hours. But what comparisons can you draw from the 2013 petition and this one?
Well, I think, and I guess what many people don't understand is that the Chief Justice himself previously chaired the Judiciary Committee on Elections. And I said this when he was appointed as the Chief Justice, that probably the best benefit of Judge Maraga is that he understands election like very few people in this country, and we worked very closely with him. Now, in 2013, one of the issues that was there in 2013 was the debate between, and I'm sorry to use a technical language, unfortunately, the procedural and the substantive law. In other words, do you knock out things on technicalities, or do you take a holistic and comprehensive view on the substance and the content of what is being alleged? Now, in 2013, a number of court petitions, as it were then, affidavits and things like that, were knocked out on technicalities. Now, the judges took a different view that substantially vacated from the decision of 2013, when they admitted all the affidavits and the petitions and the applications from both sides. Now, that was a major development. And the scrutiny, when the NASA, for example, made an application to have the ICT and technology of IBC scrutinized, in 2013, that would not have been sustained. In as much as there was some semblance of scrutiny in 2013, the fact that the Supreme Court judges had the courage to order scrutiny of IBC's servers and technology. And don't forget, they robustly objected to that. But then the Supreme Court judges did not only put their feet on the ground, but when there was evidence of dilly-dallying in terms of complying with that order, the Supreme Court told, the lawyers for the respondents, the Honorable Mwite, that wake up your, wherever it is that your server is. Now, this is two already, and if you add that to the fairness, the perception of fairness. In 2013, there was, lawyers could intimidate. There was an intimidating posture by many lawyers. And granted, that was the first experience that we dealt with a petition of that magnitude. This time around, the judges were in charge. They were in charge across the board. Across the board.
And Nelson, one of the things about the 2013 petition is that quite a number of people, especially those who were supporting court at that time, did not really feel that the Supreme Court delivered a fair judgment because of a number of issues, including some of them that Felix has mentioned, the knocking off of some evidence that the court at that time felt would have done well for them. With the conduct of the judges this time round, and the fact that you also mentioned that they seem more open, they seem more a bit friendlier maybe. Do you think that whatever judgment they come out with, that indeed it's going to be a different reception from Kenyans compared to 2013?
Yes, it is the legitimate expectation of the Kenyan people, having followed these proceedings from beginning to end, that a just decision will come out of this hearing. And look, the best way to evaluate the performance of an institution or an individual is by comparison. In 2013, the Supreme Court was comprised of half of the judges who had just joined the judiciary for the first time, with no experience whatsoever in courtroom work, with no experience whatsoever in litigation as an advocate. Now, I think, to be fair to them, they actually didn't know what to interrogate, even in respect of a scrutiny. Now, at this particular point in time, we have a Supreme Court that is comprised of judges who have distinguished themselves either as High Court judges and as Court of Appeal judges, and some even as practitioners in the courtroom, in the practice of litigation relating to election petitions. And you see, it is as a result of that that you could easily see a question coming from Deputy Chief Justice Philomena Mwilu, directed to an individual, asking the individual, look, you are telling us that the explanation as to why there were many votes for the president as opposed to the other seats is because these individuals could have voted for the president only. Then where did the other 5 ballot papers go? That is one question. Then another question that also came from that angle was, you're telling us that most of these votes came from prisons and the diaspora, and they explain the reason as to why we have about 500,000 votes more for the president as opposed to the other officers. Now, the simple answer that was given by Raila's team was, look, let's total the total number of registered voters in prison and in the diaspora. How many do they come to? They come to 9,000. And that is a fact. Even if you were to subtract 9,000 from 510, you will really not be able to justify the position being taken by the IBC. Now, you see, it is the simplicity of that aspect that brings out the transparency that is required to permeate an entire electoral process. And it's only that people are able to understand, so that should the court make an outcome one way or the other, you'll be able to internalize and see, how the court traveled through the journey of evaluating the evidence and marrying it with the law that applies to that particular situation and in arriving at that decision.
Okay.
But if you were to ask